Good day, everyone. This is Attorney Don Green in Las Vegas. Many of you know me from the gun shows here in Las Vegas or in my practice in Nevada and California, focusing principally on firearms-related issues, arrests when you're having possession of firearms, firearms litigation, opinion letters, and working with the ATF and FBI in either surrendering weapons, surrendering force reset triggers, which is a subject of another show coming up. But today's show is going to be very, very intense and focusing on a very timely issue on pneumatic guns. And today I have the pleasure of having Miss Maggie Mordaunt as a renowned expert in self-defense and firearms issues. Maggie, please introduce yourself.
I'm Maggie Mordaunt with Homeland Personal Protection and the Women's Defense Network located here in the state of Nevada.
Okay, thank you. One prime issue which has come up lately is the subject of pneumatic guns. And I just heard a commercial today about things being legal in all 50 states. We want to make it clear for the citizens and weapons owners in the state of Nevada. And when we have the first slide, please. Pneumatic weapons in Nevada require a concealed weapon permit for concealed carry because by definition they are weapons, dangerous weapons. If it expels a projectile by the use of some force through a barrel, it is a firearm by Nevada statute. If we can look at the next slide, please. Let's talk about this. Maggie, we have kids that are playing with BB guns, maybe airsoft type weapons or pneumatic pistols. Tell us about what the law is in Nevada regarding where these kids might be able to play.
They can actually take these firearms. They can take them to a gun range if they actually have outside of city limits. They can go to the desert region areas if they wanted to go out there. Just know that they are still tools that can be used to injure someone. If that goes into some soft tissue, can be lodged into the brain, causing all sorts of neurological damage. It could even cause death. So they need to treat these firearms as if they were real firearms.
Thank you. Now, you would say that perhaps this might be a good training tool?
It could be a good training tool to show them how to learn safety, how to manipulate a handgun. They even come in rifle styles, so teaching them how to keep those firearms pointed in a generally safe direction, knowing that these are still considered something that could injure someone. So not shooting at each other is really important because it's very different than that of a water gun or let's say a soft sponge type of little firearm that they have out there that is spring assisted, but it's got a little sponge that it actually does shoot out. Okay. So it's very different.
Thank you. Let's go to the next slide, please. Now, in Nevada, you don't have to actually look at the statute, but it's Nevada Revised Statute 202.265, which specifically says that BB guns and pneumatic guns are firearms under Nevada law, and you cannot carry those weapons without a CCW. Now, Maggie, you hear these commercials all the time. You see these weapons being sold at gun shows. We can't go and tell people because I'm not a policeman. I don't go and tell people that's illegal. They've got to come to me and I give them my opinion. But have you ever had a situation in which someone used a pneumatic gun in self-defense?
There have been cases where someone felt that it might be a less than lethal tool, but under that law, knowing that it is something that you have to have a concealed carry weapons license to conceal carry on the body, it is something that if someone says, well, I don't want to kill anybody, well, the goal is not to kill somebody. The goal is to stop them from continuing to present that lethal threat to you or someone else. Now, there have been cases where the criminal did get a hold of one of these because they didn't have to do a background check to buy it. You have felons that are going out and buying these guns that look like a real firearm. And unfortunately, I kind of feel like that law needs to change. That if it is considered a firearm in the state of Nevada, then maybe you need to have a background check before you can go buy it. I don't think felons should be walking around being able to buy something like this that looks like a real firearm. I think some laws need to be put in place for that.
Now, the law of self-defense in Nevada is that if you perceive, great bodily injury or death to you, your family, an immediate situation. And when someone draws this airsoft type pistol, this pneumatic gun, in my training, and what I tell people is you address the threat. It's not whether you're going to kill somebody or use less lethal. Maybe it's a moral issue with which you'll have to deal. But what would you tell your students about the use of a pneumatic firearm instead of a traditional firearm?
I personally don't teach with that sort of tool. For me personally, I'm a real firearms instructor. It's not something that I've dove into. I think that my wheelhouse is real guns. If my student decided that they wanted to use something like that, they have to be prepared for the response from the aggressor once they realize this is not a real gun. The criminal mindset has changed quite a bit over the years. You have criminals who are not so afraid of guns these days. They may have the psychological mindset that they're just going to go for it, hoping that you're not really good with guns, even trying to potentially disarm you. That lag time in using a tool, not knowing when you need to use it, or maybe freezing in that fight or flight moment, not using that proper tool or the tool that you've chosen to use, that force equalizer you've chosen to use, if it's not a real gun, be prepared for what the response might be from that potential attacker. Also know that the stopping power or the ability for this to affect the neurological and vascular system does not compare to a real firearm. Understanding that the use of force, even to defend someone else under NRS 200.160, in that law it says that we can protect other people even if they are not someone we even know. It's not just loved ones or friends that we can protect, but also understanding what you might be getting yourself into when you actually are exercising that law.
Okay. When we have a situation of self-defense, and when you're teaching your students, do you teach your students to go home and put on their holster, get their jacket or their shirt, and practice the movements which you need? Do you think that this vehicle, that this airsoft type weapon with its physical characteristics, looking or feeling like a regular firearm, would you consider that as a training tool for somebody to use at home?
It is a good potential training tool, just because it is not a firearm that actually has ammunition that's considered to be real ammunition that you would use to stop a threat. I think that any sort of tool that way, even a plastic inert form, could be something great to practice deploying a handgun from a holster. And so we call that dry practice because we're technically not shooting anything. Even with this pneumatic, you have the potential to shoot something out of it. So there is that kind of yes or no, and it's for me personally, I think it's go to the range as much as possible, at least once a month, to really practice with your real firearm. And if you're not looking to invest in a pneumatic firearm, then practice with your own gun, just making sure there's no live ammunition in the area, making sure that you give yourself at least an hour after practicing that dry practice before you do load that gun.
Would you recommend someone carry a pneumatic pistol and a real pistol?
I would not.
Why?
I don't recommend that at all, because now you're putting yourself in a position where you could potentially draw the wrong firearm, just like in the case with the law enforcement agent who went into that room and or drew from her holster. I believe it was a woman who did that.
Yes.
She thought she was going for her taser, but really went for her live gun, causing death to that individual. So there is that area where you could get confused as to what you are drawing. Is there ability to practice that sort of thing? It really depends on if you are an armed professional, if that's something you're going to do on a day-to-day basis, because that takes a lot of practice to develop some level of understanding of those automated learned responses and being able to apply that in your day-to-day job. So the plausibility principle says that, well, if you might be in a situation where you could use a tool like that firearm, it's really up to the individual and it's subjective to that person taking it serious and getting in that training along with that practice consistently.
Okay, thank you. If you have any questions, you're always welcome to call us. You'll see our contact information at the bottom of the screen. Again, this is Don Green, and I want to thank Maggie Mordaunt. Thank you so much for coming to this show and with your valuable time and your expertise. We'll be back with another segment very shortly. Thank you. Don Green signing off. Good afternoon. Again, this is Don Green. This is the next segment in our series of important and timely issues to present to the viewing and listening audience. With me today again is Miss Maggie Mordaunt. Maggie, please introduce yourself again.
Maggie Mordaunt, CCW Maggie with Homeland Personal Protection and the Women's Defense Network.
Okay, thank you. Today, again, we are presenting a series of mini programs, so it'll catch your attention. Here's one about ghost guns. Ghost guns are traditionally weapons made at home or manufactured without serial numbers. And you got to get a serial number now. Number one, it's the law of the state of Nevada. Number two, there's a Nevada Supreme Court decision issued in 2024, which held that the Nevada's requirement for all firearms to have serial numbers was constitutional, although having been declared unconstitutional by a district court judge back around 2023. And the U.S. Supreme Court has ruled on this issue in a very famous case called Bondi versus Vandershock. If we may have the first slide. Now, Maggie, to tell our audience what you consider to be, or what the authorities and what you consider to be a ghost gun.
So you have companies out there who are selling the lowers on the firearms. So typically it's not the upper, it's the lower that they are selling. And you can add your own slide to it. And when it comes to those ghost guns, they typically don't have a serial number on them. But according to that Nevada law, we must actually have the serial numbers on those firearms. And that's really something I would recommend to my students, is that they want to understand that the circumstances that may actually arise in the event that they decide to conceal carry something like that, I don't actually recommend it.
Okay, we have laws which allow, ATF laws, which allow people to make their own firearms. And the law now is that even if you manufacture your own firearm, you must have a serial number on it. And when you sell it, or when you buy one, when you look at the form 4473, on the top left of the form, right about maybe 2 inches down, it says, is this a privately manufactured firearm? Which means you made it at home. And it says serial number 123 or whatever. Now, Maggie, would you advise your students to carry an untraceable ghost gun?
I would not. I think that's going to open them up to all kinds of other questions as to the legitimacy of the firearm. Even if this firearm is maybe not made properly, it could really open them up to some sort of issue with that gun. Again, if you have someone who's just buying a parts and pieces and they're not armorers, and those are all the questions that may actually come up if you ever were to use that firearm. If something happened to that gun, or you loaned it, or if you're at the range and you and a friend are shooting it and something happens to that gun, maybe it has some sort of defect to it, he could actually be found liable for that.
When you have your students in training for the firearms portion of a concealed weapon course, do you look at every firearm for every student in that class?
I do.
Why?
I inspect every single firearm because they are under my care. If they're going to shoot a firearm, we like to inspect the guns, make sure they are clean, lubricated, they're in good working condition, just because I feel that it's my responsibility. It's the responsibility of my other instructors, as well as my business partners, to make sure that we keep our students safe on the range. There's even times where if somebody shows up with a firearm and it's not in good working condition, it's got rust on it, or it's just not a good gun that I feel safe enough to let them shoot, I actually provide handguns for my students to shoot. Even the ammunition for a lot of our different training courses. We have classes where they can use our guns. We always bring backup firearms for them to even use, because not everybody is proficient at keeping their guns in good working condition, or even know what they may even have in front of them. Maybe it's something they got passed down to them, or they haven't shot it in 5 years, and here they are at a class ready to shoot it again.
What happens if you have a student who has made a firearm himself or herself, and it does not have a serial number, what, if anything, would you do if you notice that at the range?
So if this is someone who is one of my students, again, inspecting that firearm, making sure that it's in good working condition, I would let them know and inform them as an educator that, hey, that firearm may be seen as an illegal firearm. You're going to make sure you have that serialized. Otherwise, you could get in trouble for that.
Would you allow that person to fire on their range with that weapon?
If I'm actually the range master, if I'm the person running the range, I would definitely not. I would say, nope, we're not shooting that here, but we've got some other guns that we can replace that you can shoot instead of that.
Let's look at the next slide. Now, we have a statute which talks about, except as otherwise provided, a person within this state shall not carry concealed upon their person these types of weapons, and it defines down at the bottom a pistol, revolver, other dangerous weapon, or pneumatic gun. We talked about those a few minutes ago. But now we have a law in Nevada which is talking about you actually have to have that serial number placed on it, no matter what the serial number is. And of course, you have to abide by ATF regulations, which requires caliber, 50 caliber Beowulf, 9mm, date of manufacturer, December 1st, 2026. It's got to show the serial number which you've made. Let's say it's DG666-999. That's a unique serial number. That's just the first two letters of my name, and you can pick that. But then what do? Do you go to an engraver who knows what he's doing to get that serial number and information on there?
I think it's a great idea to do that instead of doing it yourself. You want to go to a professional. Me personally, I'm a big fan of Las Vegas Engraving. They actually do a great job of being able to do things like that. They'll do some of those things that you need. They'll do it the right way because that's their wheelhouse. That's what they do. So I would highly recommend them.
Where's Las Vegas Engraving located?
They're here in Las Vegas. I'm not sure their address or anything, but you can look up Las Vegas Engraving, or you can reach out to me and I'll actually point you in the right direction.
Are they over there are they over there like the southwest corner of Decatur and Rainbow? I mean, Sahara and Rainbow, in that area?
I guess. I have no idea.
Okay, because here's the reason why you need to go to a professional engraver. Number one, the ATF regulations require a specific font. Number two, the ATF requires a specific depth in which the engraver will make that. You go to a qualified person, because if it's not, that's an illegal weapon. So let's go to the next slide, please. So, and okay, we're going into this area here, going into this while we're transitioning in from ghost guns and now to the consequences of battery domestic violence revisited. We have to plug this in here because I get so many cases of attorneys and people calling me, what, if anything, should I do? We've got a federal and state lifetime ban on the possession of any firearm or ammunition if you have a battery domestic violence. And Ms. Mordaunt, when you have a student in your class who says, well, I've got a battery domestic violence pending, what, if anything, do you do?
Well, I let them know that even in that pending status that they are not guilty or innocent. So at that time, they need to get that cleared up before they can even come in and take a class with me. And one would only hope that they didn't show up with firearms, because that in itself could put me in a precarious position that I may actually have to report that.
Okay, and so let's go to the next slide. Okay, these are different things that you've got to look at in order to be qualified. Excuse me. When you've got a battery domestic violence, you don't actually have to have a battery. It can be an assault or the threatened use of force against a person. So it doesn't have to be domestic violence in order for you to lose your rights, as long as it's a threat of force or attempted threat of force against a person where there's a qualifying relationship. So you don't have to hit them. And you don't have to, but you have to use a deadly weapon. It doesn't have to be a firearm. So, for example, if you're a CCW holder and you say that I used a machete, then that's a dangerous weapon. Would you agree?
Yes.
But we have a Nevada, here's a distinction. We have a Nevada Supreme Court case which said that the use of a butter knife is not in and of itself a deadly weapon. So the guy was charged with use of the deadly weapon, but he had a butter knife from the kitchen. So you can still kill somebody with a butter knife, but the question then becomes, you have to ask the Nevada Supreme Court how they arrived at that particular decision. Let's go to the next slide, please. Okay, we're now talking again about the remedies which we have. Ms. Mornon, tell me, when you've got a student who comes to your class and says, I've got a battery domestic violence, I'm going to plead guilty to it next week. Can I still take your class?
They cannot. They have lost their Second Amendment right to keep and bear arms. They cannot take that class. I would, refund their money and ask them to politely leave.
Now, when people come to me, and attorneys come to me from all over the state of Nevada, this year I've probably got a call from at least 3 or 4 attorneys in 3 or 4 counties in the state. So the remedy is, if you're charged with battery domestic violence, number 1, you can't go to the class. Number 2, would you try to negotiate the dismissal of the charges? Negotiate to what's known as a submittal. You do all the classes. I know that's very uncomfortable. You pay the fine, you do the community service, and try to get less than 180 days in jail. I always ask for a suspended sentence of at least at most 159 days. And then let's talk about perhaps a jury trial. So when you've got a good guy, Ms. Mordaunt, you've got a great guy with a great background who is charged with having an altercation with his wife, what do you suggest to him in your experience, practical experience, of going before a jury?
So if he's going to try to plea it, are you talking about the plea bargaining process?
Plea bargaining or jury trial.
So in that case, if they can actually bring it down and it not be domestic battery, they could give him a 3-year misdemeanor, and it wouldn't come up as that domestic battery. There have been cases where the jury agrees, yes, this person, they just had a bad day. He's not someone who has a history of violence, and because people get into arguments, things get heated, and if it wasn't something at a level that was consistent, if it was something that he's willing to, he or she, by the way, is working to take some classes. We can give them a chance to be able to get counseling and work on that, and even potentially go their separate ways if that is the case. If they're like, yeah, we're going our separate ways, I'm going to take classes, I'm going to do better. Maybe they've got some substance abuse issues that are going, alcoholism or drugs. You just never know what's going on in that person's life that put them in that position, or why they felt they needed to become violent with that individual. So I think it's not a throw the baby out with the bathwater. I think everybody deserves a second chance.
Well, what I try to do with my clients is I advise other attorneys, is try to get it, if they possibly can, a submittal, ultimately a dismissal of the charges. We're working on a couple of cases right now where it came up that for the jury trial issue, my guy was convicted before the Nevada Supreme Court issued its decision a few years ago that misdemeanor battery domestic violence offenders are entitled to a jury trial because of the substantial penalty, the loss of Second Amendment rights forever. And in Nevada, we have a very clear Second Amendment type provision in our Constitution. We've always had it. It was updated around 1979 or 1980, and we've got more clear statutes. And the background check statute itself, which I contributed to back in 2019 and 2020, says that in Nevada we have the right to bear arms. We need to keep firearms out of the hands of convicted domestic abusers and felons.
Yes.
But and Maggie, sometimes I'll consult with Maggie on what happened with do we have something here with the use of force with the wife? So tell us, Maggie, there's an argument, somebody is going to hit somebody. What do you think, what do you tell your students in your classes to avoid when there's a confrontation?
Well, cooler heads prevail. I really feel that they should try to de-escalate the situation whenever possible. We don't always have to be right. If you can, tell that person, I'm just going to go this way, you go that way. We'll come back and we can talk about it. Let's seek counseling. I think it's really important for people to understand that there are consequences to their actions, and they shouldn't just let their anger take over. Again, always taking time to calm down and know that if this is a situation where it's a relationship, don't forget about the fact that you love each other and that you can do better by each other by just backing up and chilling out for a little while, and then, seek counseling if you need to, or have a mediator.
Okay, thank you. We hope you've enjoyed this segment. We'll have another segment in a few moments once we get situated here at the studio. This is Don Green signing off for now. Thank you again. Hello again, this is Don Green, and welcome to our series of mini programs with timely issues concerning what's going on with firearms, self-defense, etc. Again, I have the pleasure of having Miss Maggie Mordaunt. Please introduce yourself as my guest, please.
Yes, Maggie Mordaunt, Women's Defense Network and Homeland Personal Protection, better known as CCW Maggie.
Let's have the first slide, please. I want everybody to know that we're giving you an update on the suspension of your concealed weapon permit for crimes or arrests. People say, they can't do it for simple assault or simple battery or even perhaps even a DUI. They definitely do it for battery, domestic violence. So I want everybody to understand that if there's the threat and use of force, whether or not it's a battery, whether or not it's battery, domestic violence, but if it's an assault, the threat and use of force or the actual use of force is going to cause a suspension of your concealed weapon permit. And what happens if you're up in Lincoln County and this happens? Well, there's a database between the 17 sheriffs. There's 16 counties in Nevada and Carson City, and they're all networked together. They all talk to each other, especially, and their CCW details are always constantly updating their files. So don't think that just because you had a case up in Lander County that it's not going to show up on the records. It definitely will. Tell us, Ms. Mordaunt, what do you tell your students to avoid most in your CCW classes?
Well, there's quite a few things to avoid, especially as a concealed carrier or anybody for that matter. Don't go to areas that are high in crime. It's always best to go somewhere in pairs. If you're going to go to a place, know exactly what the laws are as pertains to concealed carry. If you're going to go to a place like an airport or even the DMV for that matter, knowing that you can't conceal carry, but you can open carry. But also knowing that there are even other places, maybe on the strip, that don't allow firearms. Be ready to be in a better position if you're going to a specific place, to try to go during the day and not at night whenever possible. So definitely being prepared for the environment that you're about to go into.
And a lot of people don't realize that even these misdemeanor assaults, misdemeanor batteries, and we're really checking on DUIs right now, because if you have a DUI conviction in Clark County, Nevada, the law says that you cannot get a CCW for 5 years from the date of conviction, release from confinement, or the closure of the case. Not when the case begins, it's when it ends. So I always tell my clients, try to negotiate it to reckless driving or a careless driving as opposed to a DUI, because then you lose those firearms rights. What do you do when you've got people who come into your classes who said, I've got a prior DUI? What do you tell them?
So we definitely go into a lot of the qualifiers and disqualifiers at the very beginning of the class. It's not always just the DUIs that we talk about. We also talk about the use of marijuana as well, or even that domestic violence or any of those things. There's just a whole list of things that people may actually not qualify to be able to get a CCW. And DUI is something that we have seen quite often, that someone didn't know that they couldn't get a CCW because they know that they could still purchase firearms. Maybe they just bought a gun and they were like, well, I didn't know that. But it really does go into that qualification for CCW.
Okay, in the ATF form, I believe it's in paragraph 11 or 12, there's about 10 or 15 categories, and it says in one of them, are you an abuser of marijuana? And then it's got a semicolon. It is illegal under federal law to use marijuana even if the state allows it for medicinal and recreational purposes. What happens when you check yes on that form, and it's one of those auto forms that you might get one of the big box stores?
Well, definitely, if you're going to purchase a firearm and they ask that question, that's probably not a good idea to go and try to buy a gun knowing that you would have to answer yes. Nobody's drug tested when they go buy a gun. Even on our Nevada CCW application, it says that have you used marijuana within the past year, and that's 1 year of taking this class. So because we're on the honor system, because nobody's being drug tested when they buy a gun or when they take a CCW class. For me personally, it's if you show up smelling like marijuana, which, you know, it's basically smelling like a skunk, you're definitely not going to take my class. Even if someone shows up in a class and they smell like marijuana and they were not the person who was smoking it, they still cannot stay for my class because I can't verify that it wasn't them.
What happens in your class if you say, has anybody in here used marijuana in the past year or today, and that person raises his hand? What do you do?
I will basically tell them, you know, I cannot allow you to take this class. And also, I've had someone who took the entire class, and even though we talk about it at least 4 times throughout the class, because we do go over the application as a teachable moment, because there are test questions about that, all the information that's in that application within that test, I think it's a good teachable moment. But it also says in there that if you are someone who's going to ingest THC, whether it's gummies or the smoking of the marijuana, that they are not going to get a CCW, and I'm not going to put my name on their application knowing that they're protesting in the class that they're going to continue to do that. I've literally had to take somebody's application, rip it apart, and tell them they can leave now. They're not going to get a refund. They took the entire class. It was a teachable time. I gave them the services that were rendered to them, and we have a no refund policy. They're not getting a refund, even though they took the class, even though they're not going to follow the law. If you are found forced to use your firearm and a blood test is taken, a urine test is taken, and there is illegal drugs in your system, you're going to be found now charged with a felony and even potentially a homicide.
Okay, thank you. Let's go to the next slide. Okay, we're talking about, again, assault and battery. The main ones, the brandishing of the firearms. Again, you have to be careful because you don't have to be convicted of these crimes, even though they're misdemeanors, in order to have your CCW suspended during the entire time in which you are being tried for this. And it's my policy. I tell people, when it says, are you presently under indictment or information in any state court, I tell them that the FBI has suggested that a criminal complaint, even though it's a misdemeanor in justice court, is the functional equivalent of an indictment or information, which in Nevada we specifically use for felonies. But remember, the ATF and FBI are going on their own regulations, which apply with the purchase of the firearm, and ultimately when you apply for a CCW. Let's see the next slide, please. And that leads us into this, what you were talking about is training. Explain to our audience what you believe to be the process of proper training for the CCW holder in that class for those 8 hours.
So definitely a CCW class is not enough training. It's much more of a concepts class. You're not getting to draw from a holster. You're not getting to shoot an efficient amount or a proficient amount of ammunition to where you're now developing those life-saving skills. It's really just more about understanding that safety is more than just a set of rules, understanding which firearm is best for you by coming and taking a training class so you can try before you buy. I will bring out about 30 different handguns that are modern striker-fired handguns that are much more efficient and used by armed professionals. Understanding what is the best caliber for you to carry, understanding what type of gear you're going to need, a whole list of information when it comes to having a trauma kit, having cleaning, care, and maintenance products. How often do you go to the range? Taking a training course so you know exactly what to practice. Shooting a firearm is just a tool. You technically are the weapon. It's how well can you use this tool, the firearm, which is the force equalizer that you've chosen to use. This is actually something that takes a lot more responsibility. It takes a lot more investment. Putting in the time to be safe for society, but also safe for yourself, keeping your family safe, yourself safe, others safe. I have a real question for my students when they show up in a CCW class, that concealed firearms training class. It's really more about, can you really tell me that you are a benefit to you and society, or are you more of a threat as the unconscious incompetent who showed up confident in knowing that you could make a gun go bang? But there's a difference between knowing how to shoot a gun versus knowing how to use a gun in the context of self-defense. That's where we really start to talk about the science of self-defense. Human performance factors under stress, changes of blood flow to the body, and really understanding that use of force. What level of force should you be using in that situation? Are you really in danger? Or are you trying to think that, oh, just because they're doing something illegal, then they're probably going to do something else? Well, probable cause isn't really something that you're looking at. You're looking at, am I truly in danger? Is this a dynamic critical incident, a surprising, chaotic, truly life-threatening situation to which the immediacy of the danger is now forcing me to use my firearm to defend myself and shooting to stop a threat from continuing to present a lethal threat to me or someone else? Those are all the things and the responsibility that you take upon yourself, and that huge liability that you also understand that you're taking on as well.
I'm at Walmart. It's 9:30 at night, December 20th. It's cold outside, and I got my shopping cart, and someone runs up to me with a shopping cart and pins me against the car. Give me your money. I'm going to kill you. He doesn't have anything in his hands, but he's rammed me with the shopping cart. And there's 3 or 4 people with him. At that moment in time, just those milliseconds, is that a situation where I might be able to defend myself by drawing the weapon, and not necessarily shooting it, but at least drawing it? That's question number 1.
So number 1 would be that if you put your hand on your gun and you're like, get away from me, back away, I've got a gun, back away, at least de-escalating the situation in some way. It really depends on at what level of assault have they offered you already. They've already assaulted you, they've already hit you. It could be a matter of now you are responding appropriately to the situation, and what you deem as a dangerous situation, you've got multiple assailants here now. Could you draw your gun and defend yourself? You could, because you've already been physically assaulted.
Define that term, force equalizer.
So the force equalizer is a tool that you've decided to use, that you've taken training and you know how to use it to stop someone from continuing to present a lethal threat to you or someone else. Your force equalizer could be, hey, maybe you have a black belt, maybe you've got empty hand defense skills, maybe you have an edged weapon and that's your force equalizer. Maybe you have gel pepper spray, Saber Red is my go-to. Maybe you have some sort of other blunt force trauma tool that you could use, a water bottle, a flask of some sort that we carry around quite often because we're in the desert. You know, everybody's got some sort of water system, some metal water system that they could use. Could even be the door, or what about your shopping cart that you have in this situation?
In the shopping cart scenario we've given to our audience, define what you see at that moment. When I've got my shopping cart, but he comes to the edge and he pins me against my vehicle. And this is at night. It's at Walmart. There's 3 or 4 guys with him. Give me your wallet. Define what you might see as a potential level of force which I might respond.
So you've been assaulted with a cart. You are pinned into a situation where you cannot evade. In this situation, you may be forced to use your firearm to defend yourself. You have multiple attackers already coming at you. And at this point, you may feel my life is in danger. It's more than just my wallet that they may want to take. A lot of criminals are coming for money, body, or life. And in that situation, the level of aggression is thwarted towards you. You're by yourself. You're pinned. You're basically in a situation where now you may be forced to deploy that gun.
But the district attorney may argue that is the shopping cart a weapon that could inflict great bodily injury or death? It doesn't have to be death. So can the defense counter that the shopping cart itself, used in the manner in which it was not it was not designed to pin people against a vehicle, but given the time of day, it's at night, the number of people, could I reasonably argue that the weapon itself is the shopping cart?
It is a blunt force tool that could actually cause serious bodily injury or even death to an individual. We're talking about a metal shopping cart. This could actually cause injury to that individual, and would be rightfully so to the individual to feel that my life is in danger. This could cause injury. It has caused injury because you've been hit with it. I can't even imagine being hit with a metal shopping cart. They could cause a lot of injury to someone.
When I draw my weapon, they're still applying the pressure of the shopping cart on my chest. I'm 72 years old, so I'm a protected person under the statute, and I draw my weapon and I fire. What happens to the issue of proportionality of response?
So, if you are within that distance of that individual, one would say the high center chest area is your focal point. This is where you're going to aim your gun and shoot until you feel the threat is no longer a threat to you.
All right, let's change the incident a little bit. You're inside Walmart, and a little old lady comes around the corner and hits you in the back with your shopping cart. You've got your dog with you. It's a little service dog, and she hits you in the back. At that moment, can I use my weapon as self-defense to point at her and shoot her?
No. In that case, this is an accident. This is a clear accident. It would be more, me personally, because I respect my elders, I would be like, ma'am, I apologize, I was in your way, let me get out of your way. You know, again, it's for me personally, and I would only hope that others would recognize this is an elder person, it was an accident, get out of the way, give them that leeway to move out of the way, and I would just take my dog and just get out of the way. Really, I mean, I don't feel that the circumstances would put you in a position where you feel like your life is in danger.
So let's go to the next slide. So let's talk about open carry and the consequences using the situation at the auto parts store back in May or June of 2025, where the guy walks in with open carrying and a deranged perpetrator comes in and there's a fight. He shoots the guy. He kills the guy with his own gun. Tell us about. I personally don't advise my clients, and I personally tell them that I do not like open carry except at an organized shooting event, an organized event of some type where there are safety measures in place, not just walking up and down the Las Vegas Strip with loaded weapons in protest in support of the Second Amendment. So tell us your take on open carry using the AutoZone incident.
So in the AutoZone incident, the young man was already there. The homeless individual who suffered from mental health issues came in. The young man who had the open carry had his hand on his gun. He then took his hand off the gun, which in a sense, according to the story and the information, the intel that I was provided with was...
But you were also interviewed by news media on this for your expertise.
I was interviewed by Channel 3, Steve Wolford. He actually interviewed myself as well as Ken Ortega. And we were on the news talking about that. This young man lost his life. And in that situation, you have a person, unfortunately, who wasn't trained to open carry. Training is really important, and people just don't put enough stock in the fact that not only the training, but also the gear that you're going to have on. If you're going to open carry, you need to have something that makes it way harder for someone to easily grab that gun and take it from you. This poor young man lost his life. This mental health individual felt threatened by just the mere presence of that firearm and started to create some sort of story in his mind. He had voices talking to him saying that he needed to kill the person because just the mere presence of the gun triggered this person. He got a hold of the gun, and I feel that he just shot until the gun wouldn't shoot anymore, putting 10 rounds into this poor young man, killing him, taking his life. And what we can learn from the loss of life is that I think that we can do better. The young man should have had a 3-level retention holster, making it harder to get it off of him. I don't think he had the presence of mind that was going to happen. He even asked the gentleman the homeless man, is there something wrong? What can we do to help you? He's coming from a place of kindness when really that individual got triggered and decided to take his gun. Anybody who decides to open carry a firearm should have training to know how to have weapon retention. And we're talking about firearm retention. Remember, you're the weapon. Be better at being good with the tools that you decide to use to defend yourself or someone else. Concealed carry, at least you have the element of surprise. No one knows your hand. I mean, this is Vegas. Keep your hand to yourself. Your firearm should be your best kept secret. Taking training, again, that also takes training. Knowing how to deploy a gun from concealment is really important. So in this case, we can really learn from the fact that that person may not have had enough training, they didn't have good gear, and it could have actually resulted very differently had that homeless person, that mental health issue person, wouldn't have even known that young man had a gun, and we'd be talking to him today.
Thank you for that excellent analysis. Let's go to the next. Let's go to the next section, and I believe. Okay, let's go to the next. We talked about training. Let's go to the next slide, please. Train.
Please take training. Please take training.
And would you tell the audience, is the CCW class enough training for use of a firearm?
It is not. It really isn't. You know, unfortunately, and I was just talking to someone this morning about it. You know, just because someone was in the military, just because someone was prior law enforcement, guys and gals, I know what kind of training that they got. This is defense training. When it comes to the aggressors today, they have to understand that civilian training is very different than military and law enforcement. The theater of war is very different. So coming in and understanding how do we use specific firearms, because they're not military firearms, they're not even law enforcement firearms. We're talking about the civilian who has to conceal carry a gun, what type of gun, come and try a bunch of guns before you go and buy a gun. Get some reps at it, take that training so you know what to practice, know the use of force laws, know the possession laws. It is very different. The idea that ego, the idea that somebody feels confident in what they're doing because they were military or law enforcement, please do society and yourself a favor and come and take training from a instructor who teaches you how to deploy a gun in a public setting, understanding that it's defense, not offense, and getting the understanding of what you're going to go to the range and practice. As a CCW class is not enough. 8 hours of concepts information is just not enough. You owe it to yourself and you owe it to society to be much safer, not only for yourself, but to them as well. We need to protect our right to keep and bear arms and protect that Second Amendment so we give no one any ammunition to take it away from us.
Thank you. Let's go to the next slide. And that transitions us into another timely area. Question. We see this every day on the news. Protesters shutting down the freeway with an emphasis. There's cars coming towards them. There's an overpass. People are throwing chunks of concrete down, raining upon police officers and vehicles. So what do you do to be prepared when these are radicals in the street coming towards you? What do you do?
Well, whenever possible, please try to go the other way. Evade from that situation whenever possible. But if you're found caught in the middle of that chaos, you've got to do whatever you feel is necessary to defend yourself or even others who are in your vicinity or in that region. Just knowing that if you're inside of a vehicle, you're still safe in your vehicle, please don't get out. Understanding that if an individual now is banging on your window, the glass is not broken, you're still in a safe place. Glass is broken, that's where, if they're already banging on your vehicle, get ready. You really need to get ready. Put yourself in a position where if you had to use your firearm, knowing how to use a gun in a car it's a very good training that we do teach. Armed defense around vehicles, knowing that bullets will deflect and reflect off of glass. What are the safest places in your vehicle to be at? And knowing that what you can and can't do. Remember, the should versus could and the can versus can't are really something that you need to know about, and learning that in a training course is important.
Two similar scenarios. I am in my vehicle. It's 4 o'clock in the afternoon. I see this riot on the freeway. They've stopped everything on the freeway. I carry my weapon all the time. And so at that moment, when the crowd comes towards me, and you're talking about the broken glass, there's an immediate threat. At that time, can I look at this and perceive this as a threat of great bodily injury or death?
So you're happened upon that bridge.
Yes.
Bridge that you're talking about. Yeah. So in that position, I don't really feel that a firearm is going to be something that's going to save you from that situation. I feel like if you're in your vehicle and you can either get away from that situation whenever possible, you have multiple people who are on that bridge, and we don't really know who else is up there. And if you're going to start shooting in that direction, you may actually shoot people who are innocent to the situation. You don't know where that bullet's going to go. We always say don't shoot over the horizon, because you have no idea where that stray bullet could potentially go, and warning shots are illegal as well. So one would say stay in your vehicle, try to back away from the situation, and if your car is being pelted, that may force you to now be on foot.
Same scenario. I'm the same guy, but I live in Alhambra, California. I see what's going on downtown LA. I get my weapon and I drive on the freeway to go to the scene. What is the situation now?
Well, you've put yourself in a situation now where it's kind of, I kind of put this in this way in my classes. Look, if you get on the train tracks and you know the train is coming, you've kind of put yourself in danger. You can't go over there. It's we talked about this before. It was even in the Trayvon Martin and George Zimmerman case. You had a situation where there was potential of a situation that could happen, but if you put yourself in that situation, you have to now be responsible for what may actually happen after that. You don't want to go there armed with a firearm.
So you can't take a gun to a gunfight.
You can take a gun to a gunfight for sure, but you can't put yourself in the situation. It's you put yourself there. There's plenty of news media. If you're the looky-looer, if you are the rubbernecker, if you're over there trying to see firsthand because you want to feel your own fantasy idea of the fact that you were in the middle of it all, just understand that with those are going to be consequences to the actions that you do take.
But if you are caught, again, the innocent driver has his firearm. It's on I-15 here in Las Vegas in Spaghetti Bowl. If whatever happens, these rioters have stopped it, but you're caught in the middle. There's cars in the back of you. There's rioters with sticks, sticks on these placards, mm-hmm. and they have rocks. They've got professional grade gas masks who have been purchased by someone, and they've been distributed in the back of a pickup truck for free $500 gas masks. Now, at that moment, with the crowd upon me, on my car, is the crowd a weapon?
The crowd is definitely a weapon. The crowd has the ability to, when we've seen so much empirical evidence that shows that individuals can get into your vehicle. How much ammunition do you have with you? Really, I mean, it's how much ammunition do you have? How many people are you going to stop? Are you going to stop? You know, we have the ability to keep moving forward. If we feel our life is in danger and you can still move forward and get away, it doesn't matter if they're in front of your vehicle or not. You have the duty to protect whoever's in your vehicle, yourself. You have the right to do that. If I'm pinned in the front, pinned in the back, and now I'm pinned in my vehicle, and I've got multiple assailants trying to get into my vehicle, well, my gun's going to come out and I'm going to start shooting people who are now encroaching upon my safe space, which is inside my vehicle.
So this is an immediate and reasonable perception of great bodily injury or death. Is that correct?
That is absolutely correct.
Change the scenario. I'm still stuck on the freeway. There's rioters all around. And to my left, the left side of my driver's door, there is a police officer who is getting beat up and kicked. He's on the ground, face down. Can you, at that moment, draw your weapon? We got several questions. Can you draw your weapon to to defend that police officer in that scenario?
If that police officer is receiving great bodily harm with the potential of death, yes, you can actually do a citizen's arrest, which I don't recommend a citizen's arrest, but you have under NRS 200.160 to defend anybody. And then even if it's a police officer or not, if you see someone who is receiving that great bodily injury or potential death situation, that's where you could jump in and use whatever force equalizer you decide to use, whether it is you physically can do it with hands and feet, with a knife, with whatever tool that you may actually have, a crowbar out of your vehicle, whatever it is that you feel you want to use, and to include your firearm.
May I display my weapon in the defense of the officer as opposed to shooting it?
So verbal would be probably the best thing to do. We're not going to brandish the firearm in a sense that I'm going to point it at someone. I could say, I've got a gun and I'll use it if you don't back away. I could say that, but there has to be that level of bodily injury or death.
May I refuse, in my mind, to draw my weapon to help save the police officer's life?
So there isn't any law that says that we have to help someone. If we don't feel we have the ability to do something, and we don't do something, and we're found, say, on video that you're just sitting there and you didn't do anything, I mean, it's up to you, the individual, to say, I didn't feel like I could do anything, but be a good witness.
And we have these riots ongoing in Southern California. There were some riots. I'm defending a guy here in Las Vegas who was arrested for the protests against ICE last month at the federal building. They've come to me. There's a number of procedural things we have to do. But do you foresee, given what's happened in Southern California, given what's happened in Portland, given what's happened in Chicago, New York, and other states, do you see the potential for here in Las Vegas of these rioters coming here, even from out of state? Do you see that potential in Las Vegas?
We have had it in the past, so I can't imagine it wouldn't happen again. We are a very high-profile town, and it looks to me like these rioters are just looking to get the media attention. And I mean, it's Las Vegas. We are a number one visited place, and I would only hope they wouldn't come here because, you know, we depend on tourism. But I don't foresee it not happening just because it's happened in the past, and they're going to look for that glamorization to get on the news. I kind of see it happening because there's already people who live here who are like that already.
Thank you. May we have the last slide, please? Again, I want to emphasize to our viewing and listening audience that if you are arrested or charged with any crime of assault, battery, display of the weapon, you know, even if it's not battery, domestic violence, there is a substantial likelihood that the concealed weapon detail will send you a certified letter telling you that your right to possess a firearm and carry it is suspended, and it is a felony in the state of Nevada. I want to make it real clear. It is a felony in the state of Nevada to carry a firearm concealed. And if you look at our previous show just a few minutes ago, that even includes pneumatic weapons. I want to thank Rigel Studios here in Las Vegas, Nevada, for their excellent work in helping us to produce this show. And of course, I'd like to express my deepest thanks to Miss Maggie Mordaunt, who's our famous guest and who knows what she's talking about. You'll see our contact information on the streamers. Thank you so much. Don Green signing off.